did it give the claimant any condition of service for senior staff covering 2010 to 2012? That while senior staff are members of Pengasson, the management staff are not, and the claimant was a projection of management in the collective agreement between the management and Pengasson. The defendant pleads the particulars of fraud against the claimant to include: 1, claimant without any authorization ordered, received, inspected, and distributed inferior quality materials at an overbloated rate of 15 million naira. 2, despite warning, conspired with Emeka Asiki to order additional PPEs on 17th of May 2012, valued at 245,000 naira and 144,000 naira. 3, fraudulent approval of an IOU for the purchase of 350 umbrellas put at an overbloated price of 1,200 naira a piece, totaling 420,000 naira. And 4, unauthorized request for pharmaceutical product at exorbitant/inflated rates. Now, defendant's submissions. The learned counsel to the defendant identified the following 4 issues for determination in this suit. And these are: 1, whether Exhibit CW2 creates any legally enforceable contractual obligation between the claimant and the defendant. 2, whether there is any reasonable cause of action against the defendant. 3, whether the claimant can benefit and or claim under Exhibit CW2. And 4, whether the claimant has any local standing to institute this action. With respect to issue 1, learned counsel to the defendant submitted that the claimant's suit is hinged on Exhibit CW2, which is a collective agreement, that a collective agreement cannot by any stretch of imagination be called a legally binding and enforceable agreement where same has not been expressly incorporated in the employee's contract of employment. Hence, the only condition precedent for Exhibit CW2 to be binding and enforceable between the claimant and the defendant in the instance suit is that same must have been expressly incorporated in the letter of employment and or contract of the claimant. Counsel referred to the case of OSO and 40 others versus Unity Bank PSC. Citation is given. On what governs the relationship between the claimant and defendant in this suit, it was argued that Exhibit CW1 governs the relationship between the parties, and it shows that Exhibit CW2 was never incorporated into and or forming part of the contract of service of the claimant, that the claimant has also not put into evidence and or placed any other document on record wherein the defendant expressly stated that the claimant herein shall benefit from Exhibit CW2, that this court cannot go outside the said Exhibit CW1 to determine the complaint of the claimant in this case. Counsel referred to the case of Anaja versus UBA PSC. Citation is also given. It was further argued that since Exhibit CW2 was never made and or incorporated into the claimant's contract of employment by the defendant, it is at best a gentleman's agreement which is not binding and enforceable on the defendant as the employer of labor, but it's merely a matter of negotiations between labor union, that is the Pengasson, and the defendant. Counsel referred to Nigerian Society of Engineers versus OZA. Citation is given, and UBN Limited versus EDE. Citation is also provided. The court was asked to answer issue 1 in favor of the defendant. With respect to issue 2, it was posited that the term cause of action means every material fact and circumstance constituting an injury or wrong inflicted by a defendant on the claimant, which, if proved, entitled him to remedy in a court of law, that the claimant's suit is bereft of any act of the defendant that has adversely affected or is likely to affect the claimant, that since claimant's suit against the defendant as presented in his pleadings and evidence in this suit is pivoted solely on Exhibit CW2, the said exhibit not legally binding and justiciable, the net effect is that there is no factual basis which the law recognizes that gives the claimant right to claim the relief sought in this suit. The court was asked to resolve issue 2 in favor of the defendant and hold that the instance suit has not disclosed any reasonable course of action against the defendant. Counsel referred to the case of Julius Berger, Nigeria PSC versus Omogwe, as well as Sogunro versus Yeku, citations are both provided. On issues 3 and 4, which were argued together, learned counsel to the defendant referred the court to the provision of Section 3, Sub 3 of the Trade Union Act and submitted that the said provision precludes a staff recognized as a projection of management within the management structure of any organization from being a member of or holding office in a trade union. If such membership or the holding of such office in the trade union will lead to a conflict of his loyalties to either the union or the management, that the claimant who executed Exhibit CW2 in his capacity as a projection of management and as a representative of the defendant cannot in another breath contend to be a member of an O beneficiary of Pengasson, that he cannot approbate and reprobate. That since the claimant admitted under cross-examination that he is not a member of Pengasson, such admitted fact does not require any further proof. Referring to the case of Al-Hassan versus Ishaku, citation is given. That since the claimant does not fall within the category of persons eligible to benefit from Exhibit CW2 because the said exhibit was solely for the benefit of members of Pengasson in the employment of the defendant, the claimant has no local standing to bring the instant action predicated on the exhibit. That since no individual employee can claim to be a party to a collective agreement, no privity of contract arises between an individual employee and his employer by virtue of a collective agreement. Counsel referred to NBPLC versus Egun, citation is also given. It was further argued that since in one breath, the claimant is claiming the sum of 8,500,000 naira as his terminal benefits in his amended statement of facts, and in another breath, he is claiming the sum of 10,760,005 naira as his terminal benefit in his Exhibit CW4. His claim in this suit is predicated on a hypothetical guess and or wishful thinking of what his actual benefit is. The learned counsel to the defendant further posited that since the claimant was not the maker of Exhibit CW5 and CW6, nor were the exhibits addressed to him, he cannot speak to the veracity or otherwise of the said exhibits. That Exhibit CW5 and CW6 are documentary hearsay and are inadmissible in evidence. Counsel referred to Section 37 of the Evidence Act and the cases of Ute versus State and Jam versus Oji, as well as AMPP versus Usman. Citations are all given. The learned counsel to the defendant also referred to the judgment in the following cases, which are in all fours with the instant suit. And these cases are 1, Mr. Emeka Ben Obejemba versus Tekon Oil Services Limited, suit number NICN/YEN/90/2016, delivered on 18th of February 2019. Inform Michael Jeremiah versus Tekon Oil Services Limited, NICN/YEN/438/2016, delivered on the 15th of October 2021. Mr. Chinweoba Akwarandu versus Tekon Oil Services Limited, suit number NICN/YEN/439/2016, and Mr. Louis Ikechukwu Obi versus Tekon Oil Services Limited, suit number NICN/YEN/440/2016, delivered on the 14th of February 2023. The court was urged to answer issues 3 and 4 in favor of the defendant and to dismiss the suit. Claimant's submissions. The learned claimant's counsel submitted these 3 issues for the court's determination. 1, whether having regards to the pleadings and the totality of evidence led by the claimant in this suit, the claimant has made out a case to be entitled to the relief sought. 2, whether a mere averment of fraud in pleadings is sufficient to succeed and establish fraud. 3, whether the defendant is entitled to the relief sought having failed to prove them. It was submitted on issue 1 that while Exhibit DW1 was issued to the claimant and answered within 48 hours in the month of March 2012, the claimant resigned from the employment on the 3rd of July 2013, which is 16 months after the issuance of Exhibit DW1 to him. That since DW1 stated in paragraphs 8 and 16 of his witness statement on oath and during cross-examination that the claimant is entitled to terminal benefit, and also that the human resource manager of the defendant, as at the time the claimant was in the employment of the defendant, was one Lucas Nwakore, who will process the terminal benefits of the claimant upon clearance. It is obvious that Exhibit CW5, being summary of staff terminal benefits, which is referred to as memo dated December 20, 2013, in paragraph 16 of DW1's written statement on oath, was prepared and signed by Lucas Nwakore, the human resources manager of the defendant, after the claimant was cleared by the human resources manager and listed as the fourth beneficiary. That any fact admitted needs no further proof, referring to the case of Barao and others versus Consolidated Tin Mines Limited and others. Citation is given, Section 123 of the Evidence Act, that the claimant has discharged the burden of proof placed on him. Counsel referred to MTN Communication Limited versus Amadi, Bangbedin versus Oreari. Citations are also provided. With respect to issue 2, it was submitted that even though DW1 made an allegation of fraud against the claimant in paragraphs 5 and 18 of his written statement on oath, the defendant failed to establish same as required by law that fraud being a criminal allegation must be proved beyond reasonable doubt. Counsel referred to the cases of Otuko versus John, Olufomishe versus Falana, Ntux versus MPA, UKJ and Another versus UKJ, Famoroti versus Agbede. Citations are all given, as well as Section 135 of the Evidence Act. On issue 3, the Learned Claimants Counsel posited that since the defendant did not provide any evidence to substantiate the allegations in paragraphs 7, 10, 11, 12, and 14 of the written statement on oath of DW1, the defendant is deemed to have abandoned such averments in the pleadings not supported by evidence. That the defendant has also failed to provide any documentary evidence contrary to Exhibit CW1 and CW2. Counsel referred to Broward Shipping Nigeria Limited versus Ometraco International Limited. Citation is also provided. It was further argued that there is no document emanating from the defendant to support the claim that the claimant's gratuity ought not to be calculated in accordance with the provision of the condition of service Exhibit CW2. The onus of proving the existence of such a document falls squarely on the defendant, and same has not been discharged, and the defendant's oral evidence cannot take the place of documentary evidence. Counsel referred to Dr. Charles Ezenwa versus Katsina State Health Services Management Board, Akinwumi versus Alik, and Ladipo versus Falemu. Citations are all provided. The court was asked to resolve issue 3 in favor of the claimant. The Learned Counsel to the claimant finally urged the court to enter judgment in favor of the claimant. Now, court's decision. Having considered the pleadings, evidence, and submissions of both Learned Counsel to the parties, this court shall determine this suit on the basis of this single issue, that is, whether from the state of the pleadings and the evidence on record, the claimant has proved his case to be entitled to the relief sought in this suit. I have seen from the state of pleadings of the claimant and the evidence on record that his gross is simply that the defendant has refused to pay his terminal benefits despite his demands for same. His claims are clearly in the nature of special damages, which the law expects him to plead specially and also prove same strictly. He clearly pleaded the particulars of the claims in paragraph 15 of the second amended statement of facts filed on the 30th day of July 2018, which form part of his evidence in chief at paragraph 15 of his witness statement on oath, also filed on the 30th day of July 2018. The point being made by this honorable court is that the burden of proof is on the claimant, particularly in the circumstance of this case, where the claimant's case is in the nature of special damages. The claimant must specially plead not only the damages with the particulars, but must also prove same strictly with verifiable evidence. In other words, the claimant must not only plead and give the required particulars of the special damages sought, but he must also adduce credible evidence to support the claims in order to satisfy the court on how he arrived at the sum claim as special damages. He must show the court how the amount was quantified or calculated. See the case of Ndukwe Okafu and others versus Agu Obiwo and another. Citation is given. And also Mantec Water Treatment Nigeria Limited versus Petroleum Special Trust Fund. Citation is also given. And also the case of Grand Marine Oil and Gas Nigeria Limited and another versus Othner Brooks Limited. Citation is also given, where the Court of Appeal, Pasirajo JCA, held as follows on how to plead and prove special damages at pages 20 to 21, paragraphs B to B of the report. And I quote, "It is right law that special damages must be strictly proved, and by the rules of pleadings, a claimant who is claiming special damages is required to first plead the special damages and give particulars thereof before he will be allowed to lead evidence in proof. Strict proof in this context does not necessarily mean proof beyond reasonable doubt. It simply implies that a claimant who has the advantage of being able to base his claim upon a precise calculation must give the defendant access to the facts which make such calculation possible. Strict proof within the context of special damages can mean no more than such proof as will readily lend itself to quantification or assessment. In the case of Onyora versus Onyora, the Supreme Court Paros Vival, JSA held that special damages must be specially pleaded and strictly proved by the claimant. To succeed in the claim for special damages, the claimant must plead the special damages and give necessary particulars and adduce credible evidence in support. The claimant must satisfy the court as to how the sum claimed as special damages was quantified." End of quote. See also sections 131, 132, 133, and 134 of the Evidence Act. It is on record that during the cross-examination of the claimant on the 29th day of January 2020, he answered that his claim before the court is predicated on Exhibit CW2 and that throughout his employment with the defendant, he did not pay union dues as he was not a member of any trade union in the defendant being the senior staff of the defendant. He affirmed that it is not stated in Exhibit CW1 that he will benefit from Exhibit CW2, but that for the 5 years he worked with the defendant, Exhibit CW2 was used in handling their welfare and other issues, that he was not employed in the account department of the defendant, but affirmed the computation of terminal benefits by the account department of the defendant. I have equally seen that some of the high points of the answers elicited from the defendant's witness, Chief Johnny Olisakwe Maduofokwa, the international director of the defendant, during his cross-examination on the 18th of April 2023, are that it is not always that the defendant addresses the issues of fraud urgently through the disciplinary panel, and that such issue of fraud can be addressed by either the EFCC or the police if a report is made to them. That if due process is followed, a staff who is found guilty of any fraudulent act will be sacked, but that he is not aware if the claimant responded to Exhibit DW1A within 48 hours. The witness also stated that he is not aware if the claimant wrote a notice of resignation and sent to Lucas Nwokore, the HR manager, via email, and he cannot remember if the claimant resigned on 3rd of July 2013. He denied the insinuation that the defendant's HR manager, Lucas Nwokore, wrote to the claimant to return the defendant's property in his possession, that the police was after the claimant, and it was after 3.5 months that the claimant dropped the vehicle he took at the gate of the defendant, that the claimant did not appear before any disciplinary panel and was also not arrested by the EFCC or the police because he was on the run. It is supposed to make the point that the case of the claimant is clearly hinged on Exhibit CW2, which is obviously a collective bargaining agreement, CBA, between the defendant and the Petroleum and Natural Gas Senior Staff Association of Nigeria, PENGAS. Exhibit CW1, which is the claimant's letter of employment and should have been the bedrock of his case, says nothing about his terminal benefits he is claiming in this suit. The only entitlements mentioned in the Exhibit CW1 are gross fixed pay of 4.8 million per annum or 400,000 naira per month, car without a driver, 21 days leave per annum, and 300,000 naira leave allowance prorated to month staff. 13-month/Christmas pay of 400,000 naira prorated and medical insurances as applicable. I have also seen that Exhibit CW5 cannot also help the case of the claimant because aside from being a memo without any indication that same was approved for payment by the defendant, the figure stated for the claimant is at variance with what he is claiming in this suit, while the figure indicated in Exhibit CW5 is a sum of 5,285,333 naira 33 kobo. The amount being claimed by the claimant in this suit as his terminal benefit is a sum of 8,500,000 naira, and he has not shown this court how he arrived at the sum being claimed in the suit. To further worsen his case, the amount demanded from the defendant as the claimant's severance package, as indicated in the Exhibit CW4, is a sum of 10,760,005 naira. All these inconsistencies only show that the claimant is not sure of what his terminal benefit is from the defendant. His evidence before the court is clearly at variance with the exhibits tendered by him, which also contradict each other. It may be pertinent to also state that I have equally gone through Exhibits CW3 and CW6 and cannot see any value they add to the case of the claimant. Exhibit CW3 is only a response to the query issued to the claimant via Exhibit DW1A, and it has no value to the suit because the claims before the court is for payment of terminal benefits and not challenge on the termination of the employment to make the disciplinary process an issue. Exhibit CW6 merely shows that the claimant applied and obtained a loan of 3 million naira and that the defendant confirmed and undertook for the concerned staff, including the claimant. Now to come back to Exhibit CW2, which is the fulcrum of the claimant's case. There is no doubt that the said Exhibit CW2 is a product of negotiations between the defendant and the trade union, that is the Petroleum and Natural Gas Senior Staff Association of Nigeria, PENGASA, which subsequently became the defendant's condition of service for senior staff 2010 to 2012. Clause 3 of Exhibit CW2 provides for the scope of the agreement that, and I quote, the terms set out in this agreement shall be binding on the company and all regular employees of the company who are members of the association, end of quote. This clearly excluded non-members of the trade union from taking any benefit of the agreement. In essence, for an employee to benefit from Exhibit CW2, such an employee must be a regular employee and also a duly recognized member of PENGASA. The claimant informed the court during his cross-examination that as a senior staff, he was not a member of any trade union and he did not pay union dues. It is therefore the considered view of the court that since the claimant was not a member of PENGASA and also did not pay union dues as admitted by him, he cannot take any benefit from Exhibit CW2, which was negotiated by the trade union for the benefit of its duly recognized members. Another crucial point to be made is that since Exhibit CW2 was not incorporated into the claimant's contract of employment, same is not binding as to be enforced by the claimant. I cannot agree more with the learned counsel to the defendant that for collective agreements such as Exhibit CW2 to be binding and enforceable, same must be incorporated into the terms of the contract, either expressly or by implication. There is nothing in Exhibit CW1 indicating the express or implied incorporation of the terms in the Exhibit CW2. And that being the case, I hope that the said Exhibit CW2 is not binding and enforceable by the claimant. He lacks the local standing to enforce the said Exhibit CW2. I so hope. See the case of Charles Olushola Toyimbo versus Union Bank of Nigeria PLC. Citation is given where the Court of Appeal Pasala, sorry, I take that again. See the case of Charles Olushola Toyimbo versus Union Bank of Nigeria PLC. Citation is given where the Apex Court Pasalawa JSC held as follows, and I quote, however, the law is equally well settled that where a collective agreement is incorporated or embodied in the conditions of contract of service, whether expressly or by implication, it will be binding on the respective parties. See Daudu versus UBAPS per DK JCA as it then was. End of quote. See also the cases of the rector, Kwara State Poly versus Mr. Ola Adefila, Union Bank of Nigeria PSC versus Emmanuel Aderewaju Suarez. On Friday, Abalogu versus the Shell Petroleum Development Company of Nigeria Limited. Citations are all provided. In the circumstance, the single issue identified by the court is resolved in favor of the defendant and against the claimant. In the final result, I find no merit in the case of the claimant, which is hinged on Exhibit CW2. Since he is not a member of the trade union, he cannot benefit from Exhibit CW2. He has failed to prove his case. The suit is accordingly dismissed for want of proof. Judgment is entered accordingly, and I make no order as to cost.
My Lord, we thank my Lord for my Lord's industry and my Lord's time and patience on this matter. My Lord, we're most obliged.
Thank you. Okay, we'll go to the other case now.
Yes, my Lord, I want to pray my Lord's indulgence to leave. I have another matter in court.
Uriah.
Yes, my Lord.
You said?
I want to pray my Lord's indulgence to leave. I have another matter in court.
It's all right. It's okay. Thank you.
Lord, we're most obliged. Thank you very much.
Yes. Call the case.
Suit number 86/145/2018. Case between Mr. Charles Hamman and Judicial Integrated and Limited to Mr. Charles Ike.
Yes, is there any counsel? Any counsel for this matter? This is a first decision. The claimant commences suit against the defendants by way of complaint and statement of facts dated and filed on the 13th of December 2018 and claims the following reliefs against the defendants jointly and severally. A declaration that the contract of employment of the claimant and the defendant still subsists. B, an order directing the defendants to pay the claimant the sum of 4,400,000 naira, being the unpaid arrears of salaries of the claimant from July 2016 to November 2018. C, an order directing the defendants to pay the sum of 600,000 naira only, being the rental value of the claimant's accommodation for 2017 and 2018. D, an order directing the defendant to pay to the claimant the sum of 160,000 naira per month from the commencement of this action until judgment is finally liquidated. And E, 25% post-judgment interest. The defendant's statement of defense / counterclaim together with other accompanying processes were filed on the 25th of January 2019, but deemed by the court on the 5th of February 2019. The claimant filed a reply to the statement of defense / defense to counterclaim on the 29th of March 2019, which was, however, deemed by the court on the 15th of November 2019. The defendants filed a reply to the defense to counterclaim on the 28th of November 2019, sequel to the leave of court granted on the 24th of February 2020. The claimant filed an amended reply to the statement of defense and defense to counterclaim on the 28th day of February 2020. Trial in this suit started on the 30th day of October 2020 when the claimant opened his case by testifying that CW. He identified and adopted his statement on oath filed on the 13th of December 2018 and the additional deposition he filed on 28th of February 2020. The following documents were tendered by the claimant and admitted by the court. 1. Copy of staff ID card, exhibit CW1A. 2. Copy of provisional offer of employment dated 23rd of June 2016, exhibit CW1B. 3. First defendant's flyer, exhibit CW1C. 4. First defendant's flyer for training from 16th of May to 13th of June 2016, exhibit CW1D. 5. Copy of cash/credit sales invoice dated 22nd of September 2017, exhibit CW1E. 6. Copy of purchase order of Pivot GIS Limited dated 15th of June 2017, exhibit CW1F. 7. Solicitor's letter of P.N. Anosike and Co. dated 9th of July 2018, exhibit CW1G. 8. Certificate of compliance with the Evidence Act dated 20th of February 2019, exhibit CW1H. 9. Copy of email dated 18th of September 2017, exhibit CW1J. Claimant's letter of request for unpaid salary dated 18th of September 2017, exhibit CW1K. Solicitor's letter of Ahiaku and Ahiaku Good Name Chambers dated 27th of July 2018, exhibit CW1L. Memorandum of Association of the First Defendant, exhibit CW1N. Solicitor letter of P.N. Anosike and Co. dated 17th of May 2018, exhibit CW1N. Solicitor's letter of P.N. Anosike and Co. dated 16th of February 2018, exhibit CW1P. Solicitor's letter of Megwa and Co. dated 19th of June 2018, exhibit CW1Q. Memo issued by Olam dated 12th of September 2017, exhibit CW1R. Green Gold Services International Registration Form dated 18th of February 2017, exhibit CW1S. The witness CW was cross-examined by the defendant's counsel and re-examined before he was discharged on the 17th of February 2021. The claimant closed his case on the same 17th day of February 2021. It is apposite to note that even though the defendants opened their defense on the 29th day of September 2021 by calling one Mrs. Osula Ike, the then manager of the first defendant, who testified as DW1 and adopted her witness statement on oath filed on the 25th of January 2019 and 25th of June 2021. The witness, however, failed to make herself available for cross-examination by the claimant's counsel despite repeated service of hearing notices on the defendants. On the 14th of July 2022, the court expunged from the record the evidence in chief of DW1 and foreclosed the defendants from defending the suit. The defendants also failed to appear to prove their counterclaim before the court. The parties were then directed to file their final written addresses in the suit. Since all the parties and their counsel did not file any final written address and also failed to appear in court since 14th day of July 2022, despite service of numerous hearing notices on them, the court had to proceed with the judgment in the matter. The case of the claimant. The claimant averred that he was initially a manager at Final Choice Limited and responsible for opening up mega branches of the organization at Iwofe, Ada George, and Abaro, Port Harcourt. He placed his entitlements as Final Choice to include monthly salary of 100,000 naira, a sports utility vehicle, free healthcare for family, housing allowance of 300,000 naira per year, etc. According to the claimant, the second defendant, who was a customer at Final Choice Limited, noticed his resourcefulness and offered him an employment in the first defendant. He then resigned from Final Choice Limited and joined the first defendant as business development manager. He was paid 300,000 naira as rent for 2016/2017 and another sum of 100,000 naira on the 21st of September 2017 and also 100,000 naira on the 22nd of February 2018 after receiving the claimant's demands for payment of his outstanding salaries. That even though his employment with the defendant has not been terminated, the defendants have, however, refused to pay him his arrears of salaries and this has occasioned hardship to him and his family. He therefore asks for the reliefs in the suit. Now, court's decision. Having pored over the pleadings and evidence of the claimant, this court shall determine this suit on the basis of this single issue, that is, whether the claimant has proved his case as required by law to be entitled to the reliefs in this suit. It may be apposite to start by resolving the status of the defendant's defense and counterclaim in this suit, since the defendants failed to call any witness to give evidence in defense of the suit and to prove the counterclaim. The defendants who file a statement of defense and counterclaim in this suit call no witness after the evidence in chief of DW1 was expunged from the record of the court on the 14th of July 2022 because the witness failed to make herself available for cross-examination and to establish the defendant's defense and counterclaim. The legal implication of the attitude of the defendant is that the statement of defense and counterclaim filed on the 25th of January 2019 or deemed by the court on the 5th of February 2019 is deemed to have been abandoned by the defendants. Just as any evidence on an unpleaded fact is of no moment, any pleading without evidence is deemed to have been abandoned and cannot be relied upon by a court for the purpose of adjudicating a matter. In the circumstance, both the defendant's statement of defense and the counterclaim are hereby discountenanced and struck out. See the case of Union Bank of Nigeria PSC versus E.D. Emole, where the Apex Court for Ogundare JSC held as follows, and I quote, "The legal principle on this is that any claim or defense pleaded which is not canvassed during the trial is deemed to have been abandoned. See Share BP versus Abedi, Chief Adedepo Adeke and another versus Chief Obi Akin Olugbade," end of quote. See also First Bank of Nigeria PSC versus Shamsu Umaru and another. Citation is also given. Having discountenanced and struck out the defendant's statement of defense in this suit, it is obvious that the instant suit was not challenged or defended by the defendants. It is the law that the party who has the opportunity to defend a suit but fails to do so, and the suit is unchallenged or uncontroverted, such a party is deemed to have admitted the case of the claimant. The court is entitled to act on such unchallenged evidence except where same is manifestly implausible. It is therefore the view of this court that since the evidence of the claimant is unchallenged, the defendants have admitted the claimant's evidence, and this court shall proceed to give its decision based on the evidence produced by the claimant. See Chief Taufik, Ebelemu, and others versus Alhaji Mohammed Yahya. Citation is given where it was held, and I quote, "The law is tried that where evidence is unchallenged, the court has the duty to act on same," end of quote. See also Matchem Industries Limited versus MF Kent, West Africa Limited. Citation is also provided. I have seen from the records that the claimant was employed by the first defendant via letter signed by the second defendant on the 23rd day of June 2016, which is in evidence as Exhibit CW1B. He was issued Exhibit CW1E, which is staff ID card. Exhibit CW1K, CW1G, CW19, CW1N, and CW1P are all demand notices written by both the claimant and his lawyers asking for the payment of his outstanding salaries and other entitlements. In any case, I have also seen in Exhibit CW1Q, dated 19th of June 2018, that the defendants, through their solicitors, Megwa O, Megwa and Co., admitted owing the claimant the sum of 1,260,000 naira, which they offered to pay by installments. Having therefore evaluated or reviewed the claimant's evidence on record, and since the suit is unchallenged, I hold the considered view that the claimant has proved his case before the court. The loan issue identified by the court is hereby resolved in favor of the claimant. The defendant's counterclaim had earlier been deemed to have been abandoned and struck out in this suit. The claimant's case therefore succeeds in part, and reliefs B and C are hereby granted. Reliefs A, D, and E are refused because the contract being that of a master and servant without statutory flavor, the court cannot declare the employment as one that subsists to entitle the claimant to salaries for periods he did not work for the defendants. In the final result, the court hereby orders as follows. 1, the defendants are hereby ordered and directed to pay to the claimant the sum of 4,440,000 naira, being the unpaid arrears of salaries of the claimant from July 2016 to November 2018. 2, the defendants are hereby ordered and directed to pay to the claimant the sum of 600,000 naira only, being the rental value of the claimant's accommodation for 2017 and 2018. 3, the terms of this judgment shall be complied with within 30 days from today, failing which it shall attract interest at 10% per annum until it is fully liquidated. Judgment is entered accordingly, and I make no order as to cost.